watched mistake number 1. And you're here for mistake number 2 because you know that if number 2 is as juicy as number 1, you definitely want to know. My name again is Megan Truick, lead estate planning attorney here with the law office of Bryan Fagan. And I want to talk about mistake number 2. Do not do it. Don't be like Joe over there, okay? Number 2 mistake, titling your house in the name of your child. I can't begin to tell you how wrong and how much I would totally advise against this. I'm just going to name 2 reasons why you should never do this. 1, if you title your house in your child's name, and God forbid your child falls into liability, if your child has to file for bankruptcy, if your child is going through a divorce, your house now becomes an asset of that child and is subject to be taken if that child gets sued, or maybe partitioned if your child is going through a divorce. And therefore you can see that if you have worked all your life to pay for this valuable asset, regardless of how much it may be worth, this is your baby, this is your child, this is what you have slaved over all your entire life. And now because you've titled it in your child's name, this property is subjected to be taken away. You can be homeless, you can be evicted just because you titled this house in your child's name. Many people say, Megan, I'm titling it in Johnny's name so that if I pass away, Johnny will just get the house free and clear. Well, there are many ways you can do that. You can do that through a transfer on death deed. You can put the house in a trust. You can put the house in a will and say, Johnny, when I pass away, you get this house. And I'm going to tell you about the number 2 reason why these 3 reasons should really be the only way you put this property in Johnny's name. Second reason, taxes. I don't know about you, but I only give to Caesar what's due Caesar and not a cent more, and that's just how I am. I pay my taxes and that's it. I don't believe in tipping the federal government. If you put the house in your child's name, that's considered a transfer, and that's really a sale, and therefore you're going to get tax consequences at the end of the day. You're going to have to report this as a sale. For many of us, is your homestead, yes, you're subjected to this exclusion and then you may not have to pay taxes on it. But what if it takes you 20 years, 30 years to pass away? You transferred this house to Johnny when the house was worth $100,000. In 10, 15, 20 years, this house is worth $200,000, $300,000, $500,000. Guess what you just did? You gave Johnny a gain of upwards of $300,000 that he will now have to pay taxes on. There are better ways to do this. If you gave that house to Johnny in a transfer on death deed, or if you left it in your will, or if you left it in your trust, when you pass away and Johnny gets this house, he gets it at the market value today. And therefore, if he sells it, guess how much taxes he'll have to pay? That's right, my friend, no taxes. And no taxes, that's always the best way to go. My name again, Megan Truick with the law office of Bryan Fagan. And if you think number 2 point is as juicy as number 1, go ahead and stick around for number 3. Thank you. Hi, so you are enjoying the Bryan Fagan Family Law YouTube channel. Well, you are in luck. We have now launched a brand new YouTube channel that is totally dedicated to estate planning, probate, and guardianship. If you want to hear more and if you want to see more videos, click on the link in the description below and come on over to enjoy total estate planning, probate, and guardianship content. Thank you.